and then to get it to stop, hit it again. You're ready to start recording. Oh, it went ahead and started recording.
I'm the Dean of Brooklyn Law School, and I am very excited to welcome you to our very first event, sponsored by the Center for Health Law and Policy. The center opened in the spring of 2002 and is the most recent addition to the law school's cadre of centers and fellowships. As some of you are already aware, many of our faculty members are already well-known scholars in the areas of bioethics, patients' rights and remedies, elder law, informed consent, information access and privacy, scientific evidence, clinical research, and mental health law. In addition, many of them have served in the government and participated in public policy debates on health law issues. It is our hope that the center will be a place where students, scholars, policymakers, and practitioners can share ideas, debate issues, and think creatively across disciplinary boundaries to seek innovative solutions to, as we know, some very complex problems. And we invite you to be our partner in this endeavor. It is only with your participation and ideas that we can help the center grow and develop, and we hope to have, as our inaugural event, a lively discussion among everyone here. It's now my pleasure, I'm going to take a few minutes just to introduce to you the two professors who are the co-directors of our center and have helped to get it off the ground, Professor Nan Hunter and Professor Jennifer Rosado. Professor Hunter teaches and writes on health law issues, including patient rights, remedies, and public health law. From 1993 to 1996, she served as Deputy General Counsel of the U.S. Department of Health and Human Services. In 1997, she was appointed to the Presidential Advisory Commission on Quality and Consumer Protection in Healthcare, where she helped to draft a proposal for a federal patient Bill of Rights in managed care. She is, among other things, a fellow of the New York Academy of Medicine. Professor Jennifer Rosado is particularly interested in issues related to the intersection of family law and bioethics. She has given a presentation and written a number of articles on the authority of adolescents to make healthcare decisions, the deference that should be accorded when making healthcare decisions for their children, and the ethics of using children as research subjects. Professor Rosado conducts peer reviews for the Journal of Law, Medicine, and Ethics, and teaches family law, children law, and genetics and law. And I'd also like to take a moment to introduce Karen Porter, who's right over there, who is the executive director of the center. Karen is she is a graduate of Yale Law School, but she's also had a postdoctoral fellowship at the Division of Bioethics at Montefiore Medical Center. She's taught courses in health law at Washington University in St. Louis. Her background includes work as a senior policy analyst and staff counsel to the National Commission on AIDS. We were very lucky that after doing that sort of moving around, she ended up in New York and wanted to join us in this venture. So on behalf of the law school community and myself, I want to say that we're very indebted really to all three of them for helping us bring the concept of a Center for Health Law, Policy, technology to life. Professor Hunter is going to say a few words about the purpose and format of today's seminar. Nan?
Thank you, Joan. I would like to take just a few moments to welcome you to our first theory practice seminar and to explain the format for the event, which will be somewhat different than the format for most academic events. We believe that the arenas of theory and practice intersect too infrequently. That is especially unfortunate, I think, in the area of health law, which is so dynamic, and especially unfortunate here in New York City, where there is so much going on locally on issues, cutting-edge issues of health law. This theory practice seminar represents our desire to make the law school the location where health law scholars and health law practitioners who are working on the same issues can come together for dialogue. We think that this will bring enormous value to both sides. And we see these theory practice seminars as hopefully fostering a really productive exchange. And therefore, each semester, the Health Law Center will sponsor a seminar, a theory practice seminar, on some topic within the field of health law. We see these not as debates, but as conversations, which we expect will elicit both tension and synergy, but conversations between two leaders in their respective fields. And from these conversations, we hope that scholars will get a better sense of how their ideas will reverberate on the ground, and that practitioners will have the opportunity to position their experiential knowledge in a more contemplative framework than they often have the possibility of doing. We're excited about the prospect of making that happen here at Brooklyn Law School. We're especially excited about the two speakers who we have with us today, who will be kicking off this series. And I'm now going to turn it over to my colleague, Jennifer Rosado, who will introduce our speakers.
Good afternoon. When we considered our topic for the first theory practice conversation or discussion, the topic of human subject protection was on the top of all of our lists. I think it's engaged ethicists, it's engaged academics, it's engaged hospital counsel, and it's engaged the popular press and our citizens in the thinking about ethical frameworks for the protection of research subjects. And as our speakers have probably mentioned to you in their talks, is that we come to this subject under the shadow of the atrocities of Hitler and also the Tuskegee experiments here in the United States, and a long history of abuse of experimentation and of research subjects. And so with that shadow, we have been living with experimentation, but in the last 10 years, we are actually growing and encouraging more volunteers, more clinical trials. There has been an openness, a sense of inclusion to groups including African Americans and other people of color who have been heretofore excluded from clinical trials that might be helpful to the ailments that they suffer from, and with the kinds of traits that they bring that are different from white males. Women have been included in greater numbers, and children in the last couple of years have also been included. But the question remains, what ethical frameworks should we provide for them, and what remedies should we have for violations of ethical and other duties? So far, we do have ethical frameworks that are regulatory in nature, but I think the general consensus is they're not so effective. Is there anything else that we can do better? So I think our speakers today will speak to some of those remedies that might be available in the private realm, and perhaps more globally we can get to some of the bigger picture issues of where we go with all of this in terms of inclusion and protection. I'd like to introduce you to these wonderful speakers we're lucky to have today. The first is Alan Milstein. He will be speaking first. He's an attorney at the law firm of Sherman, Silverstein, Cole, Rose, and Podolsky, where he practices in a variety of areas, including clinical trials litigation, but also insurance law, products liability, and computer law. He attended the University of Maryland as an undergraduate, and then he received a master's degree at the University of Kansas and his law degree from Temple University School of Law. He has been an adjunct faculty member, he is an author, and he is probably known to many of you who know of his work for representing the family of Jesse Gelsinger in the last couple of years in the University of Pennsylvania litigation. Professor Edgar, who will be speaking second, and what we're hoping to do is to have them speak individually, but then with me in the crossfire, so to speak, we'll speak to each other, and then we're going to open up the floor for questions. Professor Edgar has been, I think, in this area for many, many years, probably as long as he's been teaching. He's at Columbia Law School. He is not only the Julius Silver Professor of Law, Science, and Technology, but also its director of the program of Law, Science, and Technology, also named for Julius Silver. He has written and spoken about a number of subjects in law and technology and law and medicine. He has been a fellow of the Hastings Center and has been a reporter for the UNESCO International Committee on Bioethics. So you know you've got some great speakers today. Mr. Nelson.
Let's see if I can get some idea who I'm speaking to. How many of you are not either lawyers or law students? Anybody? Maybe it. Any IRB members? How many of you saw the Gelsinger piece of Daylight? Let's understand what we're talking about. We're not talking about a doctor's right to practice the art of medicine with a particular patient. There's a difference between experimental therapy and a human experiment. A human experiment involves some quest for generalized knowledge as opposed to looking at a patient and deciding what's best for that patient. And when we're talking about human experiments, there's two types. And this has been, the subject of a lot of debate and disagreement that bioethicists have had with some of my ideas. And that is the division of human experiments into non-therapeutic research and therapeutic research. Non-therapeutic research is the kind of experiment that Jesse Gelsinger participated in, which is an experiment where the subject stands to benefit none at all from the experiment. Now, Jesse had OTC, but the experiment was not to help Jesse, it was to help babies born with OTC. And in non-therapeutic research, there's really two types. One is a clinical trial, like Jesse was involved in which normally in an escalation of dose, you give the subject a drug, or perhaps use a device. And the other is what's called a challenge study, which is the kind of study that Alan Roche was involved in at Johns Hopkins, where a human subject is, in essence, intentionally harmed. That is, injected with something, and then the scientists measure the response. Therapeutic research, again, it is research involving a ill subject who stands to benefit, or at least is told that he or she stands to benefit by participating in the experiment. Now, this has obviously been the subject of a lot of controversy recently. And for some reason or other, I seem to get blamed for a lot of this, as if somehow I've started the whole thing, and it's the lawsuits that are really the problem. And it's not my lawsuits that have started this debate, this raging debate. It's in recent years the deaths of people like Alan Roche and Jesse Gelsinger, experiments such as the one that took place at the University of Oklahoma that I'm involved in, and just the proliferation of research that's going on in this country. Now, one of the myths out there is that everybody's watching. The IRB is watching the researcher, the OHRP is watching the IRB, the FDA is watching the OHRP, and the Senate and our executive branch are watching the FDA. The truth is that in most experiments, the protection of the human subject is up to the researcher's ethics, because there's just so much of this stuff going on. The estimates are anywhere between 100,000 and 300,000 human experiments involving 7 to 8 million participants. At Hopkins, when Jesse Gelsinger was killed, there were 4,000 protocols under review. At Johns Hopkins, when Alan Roche was killed, they had 2,500 protocols under review. There are 5,000 IRBs in this country. So what I have advocated as a partial solution to some of the problems that we're experiencing is reduce the number of clinical trials. Now that seems like just utter hearsay. You know, you're against medical research. You're trying to stop the advancement of science. No, I'm not trying to stop the advancement of science. What I'm saying is, it's a myth that every experiment that's going on today is critical to the advancement of medicine and science. The truth is that a lot of the experiments that are going on for no other reason than that the researcher needs tenure, that he needs to get some grants, that a drug company wants to add an indication to its drug because its drug is coming off patent. Then there's a whole proliferation of Me Too drugs where another drug company is sort of tinkering with a drug and changing it in some way, coming out with another drug that does the same thing as Rogaine, for instance. Now, some people may think, well, we can never have too many drugs that do what Rogaine does. Human experiments. To use a human being in an experiment. The experiment has to be important. Human beings aren't chattel. Now, a lot's been said about conflicts of interest. And some of the proposals that are going on today are that financial and other interests that potentially can shift the focus of the researcher from the importance of protecting the human subject, that these can be managed. And that the solution is to simply disclose to the subject that there's a financial interest that the researcher has. And to have conflicts of interest committees within universities to manage these conflicts. And what I have argued is that these conflicts of interest can't be managed. They were attempted to be managed at the University of Pennsylvania. They had a conflict of interest standing committee. They disclosed to the Gelsinger family that the researcher had an interest in the outcome of the experiment. But it was just sort of a tagline at the end. Now, when we talk about a human experiment and the ethical requirements that are important to make sure that that experiment is ethical, we're talking about at the inception of the experiment, at the design of the experiment. An unethical experiment isn't made ethical by informed consent. An unethical experiment isn't made ethical by a result that's good for society. So what do you need to have an ethical human experiment? First, all the preclinical work must be done before you experiment on a human subject. In the Gelsinger case, after Jesse died, after the 18-year-old kid dies, the researcher does some additional research on mice and determines that the adenovirus vector it was using can cause an extreme immune response. But you can't do that after you kill an 18-year-old kid. Now, maybe that's a strict requirement. And of course, there's some very tricky issues in some medical experiments where the doctors say, we can't do all the preclinical work on animals. We have to do it on humans. We can't know what the universe of harm is until we experiment on humans. And so the ethical question is, well, if you don't know, can you still do the experiment? If you don't know the universe of harm, can you do the experiment? Even if, and particularly if, the goal was so important. To be ethical, the design of the experiment must be such that it's using valid and good science. That is, the population that's being tested must be large enough so that the results are significant. That there must be a likelihood of gaining knowledge by this experiment. One of the overlooked requirements of Nuremberg, which goes to what I was talking about earlier, is that the experiment is ethical only if it is, we're talking about a valuable set of conclusions that are attempted to be reached. In Nuremberg, they talk about fruitful results for the good of society. The risks must be minimized in any experiment and outweighed by the benefits. Now, what does that mean? In a non-therapeutic experiment, remember, the subject is not going to benefit at all. Now, one of the standards that I use, and some other individuals have used, to talk about the standard that we're talking about that's acceptable in non-therapeutic experiments, is this Hebrew phrase, shomer patayim. Any Talmudic scholars in here in Brooklyn? No? What?
Where would you find such a thing in Brooklyn?
And shomer patayim means God protects the fools. And what that means is, we're all such idiots. You know, if you remember your college days, you know it's a miracle you got through, that you survived. So we're all such idiots. But God makes sure that we don't kill ourselves in our ordinary life, that we get through the day. And so the standard that I think should be the standard for non-therapeutic research, where there's no benefit to the subject, is that the risks should be no greater than the risks of everyday life. And for therapeutic experiments, the standard should be what's called clinical equipoise. That is, a real uncertainty in the minds of the researcher between the one arm of the study and the other arm of the study. So for instance, what would you all think about a study, maybe you remember 20 years or so ago, a lot of cancer patients wanted to take Legatron. Now, the doctors knew, or at least thought they knew, Legatron didn't work. What do you think about an experiment where you're testing the efficacy of Legatron? Can you do that? Can you test Legatron against standard best therapy and see if it works? No, you can't do that because you know it doesn't work. So even if it's important to prove it doesn't work, you can't do it. Which also, added to that, is that there must be an ethical use of placebos. You can't use, scientists love placebos. They love double-blind studies with placebos in one arm because that's where they get the best scientific results. But you can't do a study with placebos if they're standard best therapy. One drug company proposed to do a study down in Latin America involving pregnant women with AIDS. And they were going to have two groups. One group, they were going to give this new drug they were testing, and another, they were going to give nothing. Now, in this country, we have a standard best therapy. The scientists, the drug company, didn't want to test the new drug against standard best therapy because they didn't think they would get a result that they could understand. Now, their argument was, down there, nobody was going to get the drugs. There isn't any standard best therapy in this poor area. So of the 100 women or so in the study, if we don't go down there and do the test, none of them will get any treatment. But if we go down and divide them 50-50, at least 50 will get this new drug. What do you all think about that? Can you do that? Any response? It is unethical. It is unethical. And one of the important things that's come out in recent cases essentially says that there is this fiduciary relationship between a researcher and a subject. So once these women, all of them, become subjects in the experiments, the researchers have the duty to give them at least standard best therapy. The selection criteria, there must be equitable selection, and it's not centering on prisoners, blacks, Jews. There must be an absence of coercion, and you have to avoid vulnerable populations. And what is the most vulnerable population you can think of? Children are a very vulnerable population. No question about it. How about the dying? How about the terminally ill cancer patient? Or how about a cancer patient or an AIDS patient desperate to get well? Now, informed consent, the requirements in the CFR, we've got to set out the purpose, the procedure, the risks, the benefits, the selection, the alternatives, the financial interests. Now, I've talked about uninformed consent, the myth of informed consent. And it's my position that the document neither evidences that the participant is informed or that he or she consents. Let's talk about this. I don't even like that phrase, informed consent. One of the problems with it is, if you ever go, when you go get your flu shot, when you go get any kind of surgery, you sign a document called an informed consent document. It's the same name as the document you're signing in a research study. It shouldn't be. They're different documents. And just medical, the document you sign for medical care, in essence, allows the doctor to do a procedure order so that he can't get sued for a bad. If you don't read it, you don't read it. It's like your mortgage or insurance. If you don't read it, that's your tough luck. If you sign it, you let him do it. And if you've ever gone and gotten your flu shot, the doctor hands it to you, do you read it? I don't read mine. And anyway, the doctor says, sign this, the lawyers make us do this. Think of that name, informed consent. And I've heard researchers using that as a verb. Well, it's now time to go informed consent, the subject. It presumes consent. What we're talking about when we're talking about human subject research should be informed choice, informed decision making. I've said to researchers, why don't you use the word human experiment, the phrase human experiment or experiment? They use the phrase, what they constantly use is the word study, clinical trial, research. They don't like to use that word experiment. Why not? I've asked them in depositions. Maybe that's at the friendliest setting. And the response I get is, well, I don't use the word, I never would use the word experiment because it carries too much baggage. It's got too much weight. Because it brings up the Nazi situation. And my answer to that is, the beautiful thing about the English language is that words carry so much meaning. That's precisely why you have to use that word. Again, the document in research is meaningless. It's only supposed to be a record of a discussion that takes place. The fact that someone signs it is meaningless. The researcher must truly believe that he or she has conveyed all the material information to the subject, and that the subject understands it all, is competent to give consent. And it's the researcher that's got to have this discussion, the principal investigator, or perhaps the head person and the head nurse in the team of the investigators, who must have this informed consent discussion. One of the serious problems that researchers have is something called the therapeutic misconception, which is in so many of the cases that I'm involved in. The therapeutic misconception essentially says that when you're dealing with an ill patient, let's say a cancer patient or an AIDS patient, or let's say the mother of a sick child, that individual wants one thing and one thing only. Either to get themselves well, to get the child well. I don't think you see a lot of altruists on the cancer wards or the AIDS wards or in the children's hospitals in this country. And when a researcher looks, when a scientist, who also happens to be a medical doctor, looks a patient in the eye, and the scientist looks at the subject in the eye. And this medical doctor is trained in the art of medicine and good bedside manner, and conveying caring and healing. It doesn't make a difference what that doctor says to the patient. It doesn't make a difference if the informed consent document contains the laundry list of risks, spells out in huge letters. This is an experiment. We don't know if it works. It doesn't make a difference. That patient sees themselves not as a subject, but as a patient. Believes the doctor thinks it's in his or her best interest to be in the study. And this isn't just my, I've made this stuff up. There have been articles written about this. There have been research conducted on this. That even in phase 1 studies, phase 1 cancer studies, in which there's a less than 3% chance of the subjects benefiting at all, 70% of those who agreed to participate believed it was the best treatment. 50% believed they were getting standard treatments and procedures. 70% believed it was in their best therapeutic alternative to be a subject in the experiment. 90% believed that the purpose was to benefit them, not the subject. I put this Dewsbury quote, I don't know if you can read it. The problem here is how the drug companies and the advocacy groups portray what goes on in a human experiment. So here in the Dewsbury, there's a birthday party for an AIDS patient. And his friend says, I've been racking my brains to find out what to give an AIDS patient. And he opens it up and says, why? It's an unproven AIDS drug. And his friend said, the stuff turns mice blind, but hey, life's short. And if you talk to cancer patients or AIDS patients, and you hear them talk about getting in a clinical trial, it's like getting into law school. How lucky they are to get into this trial. Because the way these trials are marketed is that, the FDA is just a bunch of red tape. We got the drugs that just haven't been approved yet. If you get in a clinical trial, you will have the latest and the greatest. You'll have the cutting edge medicine. If you look at the National Cancer Institute's literature, they talk about the reason to enroll in clinical trials. Because it gives you access to new drugs and intervention, an opportunity to be the first to benefit. And it's better that you get better care than in standard best therapy. And it's the best therapeutic alternative. Now my solutions to this are that you got to tell it like it is. Call it a human experiment. Use what's called subject advocates. There's got to be some learned intermediary between the researcher and the subject, so that this doctor can tell the subject what benefits he or she can really expect to see. There's got to be an explanation of phase 1, phase 2, phase 3 trials. The researcher should know whether or not being in the research is the best therapeutic alternative to that subject, and they should stop selling. Now, who are the responsible protectors of human subjects? It is the investigators, the IRB members, the subject advocates, the OHRP, the government entities, and it's all of us. You know, it's so interesting how this field is so much the subject of the media today. And in a lot of the cases that I quote, how they've gained such national attention. Not like a medical malpractice case. And I maintain what I do is not medical malpractice. And why is that? Why is what happens to a Jesse Gelsinger different than what happens with a typical medical malpractice case? And the reason is because when a human subject participates in an experiment, he or she does that for all of us. For all of us. We're all responsible. That is, if it's for the good of society, for the future of our children and our grandchildren, if we're the ones benefiting from this subject's participation, we're involved. And that's why one of the things I have said a number of times is, and if maybe you don't know where that phrase comes from the Hemingway book. It comes from an essay by John Donne where he says, in essence, if you hear the funeral bells, then it means one of us has died. And since we're all in this together, and if I can relate it to human subject protection, when a Jesse Gelsinger is harmed in a human subject experiment, and you hear the funeral bells, well, the bells don't just toll for him, they toll for us, all of us. We're all involved.
I was asked to comment, really, rather than to prepare a separate paper on my own. I should say that I also came into this field as a plaintiff's lawyer. One of my earliest experiences in actually litigating cases was when the Tuskegee syphilis cases were filed out in Alabama. And it was my good fortune and great interest to serve as the lawyer's lawyer, in effect, figuring out how to file the complaints and bring those cases. So a lot of the issues that show up in Alan's complaints are ones that we struggled with back in the early 70s, trying to see whether or not it was possible to fashion plausible relief for people who had been harmed in the course of this 40-year study by the United States government of untreated syphilis. It seems to me useful to think about where we have come from and where we are going to. As I see it, over the last 10 years, we are seeing at last a collision, which I had long anticipated and indeed am surprised that it took so long to occur, between, on the one hand, well-meaning language drafted by ethicists to kind of capture moral intuitions about how research in an ideal way should be done, put forth in the Federal Register, and on the other hand, people who are real lawyers, accustomed to the hurly-burly of the lawsuit, who read text very, very carefully and say, well, did you do this, did you do that, etc. The IRB regs and the documents that have been in service were never meant to sustain that kind of close examination by real lawyers. And so now the question we are going to have to sort out as a community in this area is how to adjust our aspirations on the one hand and the reality of what can be done on the other as the research enterprise becomes a larger and larger business. It's economically an industry of enormous consequence. There are many hospitals, both in this city and around the country, that are principally supported by it, and somehow or other we have to try and achieve a synthetic view, a synthesized view of how we will treat these issues. Let me talk for 5 or so minutes about how we got here, and then let me raise, in the theory way, 4 or 5 legal questions that I think are interesting, that grow out of some of the cases that Alan has brought. The odd thing is, why is there so much writing? Why is there so much extraordinary interest in human experimentation? Particularly when, until recently, it could not fairly be said that taking all the tragedies, and there have been many, in the conduct of research in the United States, they do not begin to compare with the amount of injury that is caused by just your ordinary incompetent doctors. Far more people are killed every year in the United States by physicians who are drunk, by physicians who have problems are not competent to do the work that they're doing. Ordinary folk, not research physicians. This is a much bigger problem. If you look at the recent study through the IOM of the incidence of medical failure rates, of complications of prescriptions being misread, these are defects in the system of healthcare that produce much more damage than anything remotely caused by failures in medical research. Despite that, we have about a 35-year history of extraordinary energy and worry about medical research and medical experiments. Why does it so capture the attention of our culture in this time and place? Several reasons. First and most importantly, the Nazi experience, the way in which it was seen how even an institution as powerful and extraordinary as the German medical establishment could be corrupted by the politics of Hitler. Partly our own recognition, never really fully acknowledged and lived up to, that we did a lot of things in those days that weren't too, I mean, they were nowhere near as bad as what Hitler did, but the true story of the American research experience was never laid out in a way that people could appreciate it. But I think as well, because the medical research context is the single best illustrator of the conflict between deontological and utilitarian feelings and beliefs in the United States. Because the research enterprise is basically utilitarian, right? If you've got to sacrifice a life or two to find out something important, why not? As against that, the belief, particularly the post-war belief, no, you can't sacrifice individual rights to the community's desire to know something. That tension is so powerful that it serves as a metaphor for a lot of contemporary anxieties. For whatever reasons, what happens in the 1960s is the medical establishment, to defend itself. This is not, the rules about which we will talk are not rules that get imposed on medicine from outside, the way the FDA law gets imposed after the breakdown caused by the thalidomide experiments, or the realization of how poorly under control were the mechanisms for marketing new drugs. Rather, the medical research establishment, in the face of a number of scandals, decides that they've got to do something to make sure that the FDA, that the procedures for doing research do not become as complicated as the kind of rules that exist at the FDA, where you have to go through so many hoops to get the authority to do things, at least until quite recently, that it adds enormous cost to each and everything you do. So in 1964, following the scandals at the Jewish Chronic Disease Hospital, where elderly patients were having cancer cells injected into them in order to see whether or not the elderly immune systems would clear these cells at the same rate as healthy people. It was noticed in that context that this experiment could not have been done on an NIH campus because NIH already had ethics reviews committee in place looking at what was being done on site in the NIH clinical facilities. Nothing comparable existed when the federal government was spending money for research to be supported at places like Columbia and all the other research institutions around the nation. So as a matter of administrative law and a grants manual, the government came up with a rule that you could not get federal funds for research unless you promised that the research would be conducted in accordance with certain ethical standards. No support in statutory law for it. It was an innovation taken in a way of, as bureaucrats do, to get ahead of a problem that people knew was potentially out there and dangerous. When the Tuskegee syphilis problem broke in '74, Congress passed the National Research Act, basically directing that regulations like these be made a part of federal law. And that is the source of the so-called IRB regulations, which are in the Code of Federal Regulations 46 CFR .45 or 4046. And these regulations are extraordinary because they lay out rather complex things that you have to do if you are going to get money for federal research. As Alan noted, bad science is unethical science. You have to have a committee. You have to review whether or not the science that you're going to do is appropriate science. You have to do informed consent procedures. All this is required if what you're going to do is, quote, research. But lacking in the discussion is why is research the way in which we should divide the universe of medical activity? Just as an illustration, if a surgeon wakes up one morning and thinks that the right way to treat your psychiatric disease is to burn your brain with some palladium, and surgeons occasionally think this isn't research, because he's not doing it in an effort to get a generalized theory of knowledge. He just thinks he knows what's best. Absolutely no requirement to go get an IRB approval or anything. The less informed and sensitive people are about whether or not what they're doing really warrants other people looking over the shoulders, the people who are most arrogant do not fall under the scope of present federal law. So you have these rules that come in, and then committees. I mean, I often think that the IRB was invented by the Xerox company because it generates just enormous amounts of paper, people looking over other people's paper, informed consent documents. Nobody, or almost nobody in my experience, actually regularly going out and seeing what do the patients who are given these documents actually understand from them. It is a technique by which we do something, but by no way is it realistic to think that the amounts of energy that we put into IRB review is going to catch all the problems. It can't possibly work that way. Alan points out, although I would not at all adopt his remedy, the simple number of research protocols that are being run in a major institution so far exceed what the capacity of any group of people are to actually monitor and keep up with all of them. The IRB regs contain the rule that an IRB must keep up to date on whether or not the risk-benefit balance contained in a research protocol is current. That would mean the IRB members would have to become knowledgeable about each week's, month's scientific publications to decide whether or not this protocol was still valid as a protocol. It can't be done. And so what you have is rules that I think have worked well. I do not, by criticizing them, deny at all the transformative impact they've had in the way research actually gets done in American hospitals. It's much better now than it was in the 1950s and 60s, and no one remotely knowledgeable about the situation will doubt that. In part, just people coming together and saying, I'm going to do something like this, gives so many more alternatives and opportunities for people to say, they're going to do what? And so people do better than they did. In that sense, the IRB rules have worked very, very well. But the shortfall between the vision of what they would be like if anyone were actually capable of fully applying them and the reality is extreme. And so now what we're seeing is lawsuits that come and try and capture and monetize the difference between the pretensions on the one hand and the sloppy reality of institutional practice on the other. How will that affect the good ship research, clinical research in the United States. Let me give 3 or 4 or 5 what I think of as very interesting legal problems for us all to kind of chew on and reflect on. One is, does the failure of an institution to follow appropriately the IRB rules give rise to a cause of action when somebody is injured in a clinical protocol? I should step back a bit and say, at the time the IRB rules were put out, and indeed at the time the President's Commission in the mid-70s, if my recollection is right, studied the working of the IRB rules, perception was that clinical research was not very dangerous. They had discussions, for example, as to whether to require strict liability for injuries to research subjects, and it was debated back and forth. Would it be hugely expensive? They found out by looking at one place that actually had such a rule and insurance policy, they were paying nothing for their insurance for this. It was not an expensive form of insurance because the incidence of injury was so small. Will that change as we go through some of these IRB issues? First issue, person injured in an experiment where when you go to the experiment, you see that the IRB procedures were not properly followed. They could be not properly followed for either were not followed or were obviously wrong. Not followed possibly for several different reasons. Let me take reason one. Suppose the judgment is the materials that went before the IRB, the researcher did not present to the research review committee the full set of materials that bear on the question whether or not this is a good piece of research to do. Now here you get into the trouble that death sharpens your sensitivities to what might be relevant for the committee to investigate. When somebody dies and you actually go out and investigate all the world's literature about a problem, you find out things that you say to yourself, gee, I wish I knew about that. But that's life. People don't realize everything about the implications of the work they do. But here, let's suppose the researcher did know a little bit about it and didn't put it forward. Is it actionable that the committee never saw something that might have influenced their judgment about whether or not to permit the experiment to proceed? Not sure that they would have, but it might have. Is a suit successful on the grounds that you didn't follow the regs, the procedures weren't right, the experiment shouldn't have been done on these papers, the patient or the person who was injured should be able to recover the loss? Next, suppose stuff was there, and the judgment of the people at MIT is, you mean they did that in Oregon? I can't believe it. Can you get to the jury on the question of whether or not this was good science by bringing in expert witnesses to undercut the scientific theory that was presented by and to the IRB, with the expert witnesses saying only a lunatic would have done an experiment like this at this particular time? So that's one set of problems. Next set of problems is, suppose there's something wrong with the informed consent. Suppose, for example, the individual wasn't told something that should have been told on the list. These lists that Alan had up of what are presently required for disclosures and informed consent. For many years, there was a requirement that you tell people whether or not you were going to reimburse them in the event of injury. But there was no requirement that you tell them that you made $1,000 if they said yes to participating in the experiment. Nothing about financial interest as a requirement of disclosure in order to establish informed consent. Suppose something that was supposed to be in the consent form isn't there. Again, is it the burden of the plaintiff to show that, had it been there, the plaintiff's deceased would not have accepted the experiment? Or is it sufficient that the damn thing wasn't right, and if it's not right, it's the institution's fault? Third on these, and this is one where a fair amount of litigation is going on, is, do you need damages to recover? I faced this in syphilis cases. In the syphilis cases, we had 200 people who were control group members. They had not been injured by virtue of being in the syphilis trials at all. They were instead used as the metric against which their colleagues and fellow citizens' rate of death was evaluated. I thought this was horrible and wrote a complaint saying that the control group too should recover, because this was in effect forced participation in unconstitutional, legal, and moral, and damn it was wrong, medical experimentation. We had one more wrinkle there, that the very fact that the control group was being looked at by the doctors arguably influenced the rate at which they sought medical attention for other things that were wrong with them. And many of the control group, by the time the lawsuits got going, had serious problems like hypertension and cardiac disease that nobody had taken care of, even though government doctors had examined them, seen that they had these problems, and arguably should have said, you better go get yourself to a doctor. In any event, the government paid off the control group, settled with them, not as generously as with the people who had had syphilis, but they did it. But this issue of, is it a violation of dignitary standards? Can you get nominal damages by virtue of the fact that you have been put into an unethical experiment? With respect to government arguments, government actors, you can claim, yes, you can under the Constitution, with the theory being that the Nuremberg standards imposed by a United States court, after all, in the 1940s, reflected international consensus about human rights, the same necessary consensus that underlies judgments about the meaning of the Due Process Clause, i.e. the same technique that permits 3 United States judges to hang Germans on the grounds that the world accepts and recognizes as a universal moral norm the idea that consent is necessary before untherapeutic experimentation. That idea also, therefore, is to be found in the broad meaning of the Due Process Clause, using the standards of Roshan in cases like that where you look for the consensus of mankind. Perhaps with the Supreme Court's recent mentally retarded death penalty case, that technique of asking what's central by looking to broad consensus of jurisdictions and rules come back. So with respect to a government experiment, at least where it's non-therapeutic, where nobody thinks it's benefiting the individual who's engaged in it, maybe you can say that that's a constitutional harm. Then obviously if you've got big damages, good luck. But if you've got no damages at all or little damages, can you get the $500 damages that will then permit a jury to say, and punitive damages of X? Because the game is punitive damages of these things, where if you have a class of 100, 150 people who've been in an experiment, that can be a tremendous amount of money if a jury thinks what's going on is absolutely wrong. With respect to cases where there's no government involvement, so you can't implicate the Constitution, can you get to the same result, basically, under a state tort theory, that either this research approach towards of IRBs and committees has become so central to the conduct of research, so much so that the rest of the world has now adopted it. It's now part of the international standards for the conduct of medical research under the Declaration of Helsinki as amended in Rome and subsequently Tokyo, that you can say the same thing. To put somebody without adequate and appropriate knowledge into an experiment is to deny them their human dignity, and if so, at least minimal damages should be permitted. Article 7 of the I can never get it out straight, the Convention on Civil, and Political Rights, to which the United States is a signatory, makes it an obligation of governments to protect against unlawful experimentation. It is a fundamental, internationally protected human right to be free of unconsented experiments. So, can you get that? Now, if you can, I'd hate to be one of my friends responsible for what do I do if I'm running a research institute in a world in which the standards are sufficiently, are well-meaning phrases that people never really sat down and said, now what exactly is this going to mean in an institution that has to process 300 of these things a month on the one hand. And if you get anything wrong, there's Alan saying, or someone will say, you've just violated someone's international civil rights, and at very least, you owe me $50, and I have a right to ask the jury to offer these people in the cancer cases. And by the way, I have seen lots of volunteers in late-stage cancer wards. In my experience, a lot of people in that setting do want to volunteer. They will die anyway, but in the context of the description of the program, you can make it sound as if everybody's keeling over and dying as a result of the administration of the disease, of a particular drug. And so people want to settle fast. The Vanderbilt settlements, paying a lot of money in situations where, had they strung it out along, they might well have had to pay a lot less, but they couldn't take the heat. Final question is, it obviously puts even more heat on when you sue the IRB, because most of the IRB members are not used to waking up in the morning and having a summons in their box. Particularly the lay members who are friend or trustees and thought they would be, that they would volunteer for some community service, and all of a sudden they've been summoned into a lawsuit. They make telephone calls and say, what is going on? Get me out of this, no matter how, and do it yesterday. Do IRBs and should IRBs have any form of qualified immunity? We're all familiar with hospital committees and the whole issue of the extent to which various participants in hospital review committees have immunities of various kinds. In the IRB context, it's not easy to see how they have immunity. On the other hand, they are serving on federally required committees. Can you borrow from the federal mandate to say that even while they're not federal actors in any way, that by virtue of service that somebody's got to do on a committee required by federal law, that it is appropriate to create qualified immunity. As a practical matter, from the tort lawyer standpoint, you don't need these people for any money. Maybe you want them because the deposition is easier to introduce in their absence. But in terms of real cash, if the institution doesn't have the cash to pay, you're certainly never going to squeeze it out of the individual IRB members. Anyway, those are some thoughts about practical tort issues that might come up.
Alan, I'm sure there's a lot you want to respond to. I'll let you choose what you want to respond to. And I thought it might be helpful also is as you respond to give some examples also from the litigation, but really to have a chance to in the initial presentation that you can talk about.
Sure. As the last point, I have made it a practice to sue IRB members, and they really hate that. And I think the professor's right. It's not done for money reasons, because I know that for instance, in the University of Oklahoma case, the University of Oklahoma indemnifies the IRB members. So why do it then? Well, in the University of Oklahoma case, the authorities who came in there and examined, this if you don't know what it is, there was a doctor out there at the University of Oklahoma Medical School in Tulsa who believed that God had given him this cure for cancer. So he decided, and he developed this vaccine that he said was this miracle cure for melanoma. And they started recruiting patients, most of whom had no insurance and just wanted to get well. When the authorities came in and closed this thing down after a whistleblower alerted them, they found out that the IRB was just totally asleep at the switch. And the phrase in the FDA documents were that they used to meet once a month for an hour with dinner to follow. So the point of suing them was really to just change the way IRB members think. It's not an sort of an honor to be named to the IRB. It's not something that, okay, Joe Schmo has been a good contributor to the University of Oklahoma, so we're going to put him on the IRB. It's a serious responsibility, and there's a lot of work to do. And with respect to related to that, with respect to the question of what happens if they fail to do something they're supposed to do, such as at the University of Oklahoma, where they just failed to do anything they were supposed to do. Yeah, there is liability if you can if you can connect the dots and say, but for their failure to follow this regulation, this experiment never would have happened. Likewise, if you can get an expert, and I've gotten experts to say, this is just stupid stuff. We would never have done that. It's bad science. It's a bad theory. The risks are too high. The benefits are non-existent. The population is too small. There's never going to be anything critical that comes out of this. It's a bad experiment. Well, if you can get somebody to say that, then I win. And if you can get somebody to say that the informed consent document, the informed consent process was lacking. So if there is, for instance, in the Gelsinger case, they did not tell the family that there had been monkey deaths with the vector used on this 18-year-old kid. Now that's material information. And if they fail to tell the family that, I don't think it becomes a question of fact would the parents have said yes or no. And what happened in the case I had out in Seattle was you get summary judgment in that situation. If the informed consent process didn't work, then there was no informed consent. If there is no informed consent, then the kid never would have been in the experiment. It was a battery, and I win. So these, to me, these aren't just technical rules that we sort of wink our eyes at because we ended up being followed. All these regulations have to be followed. They're important. And they're important for the protection of human subjects.
Alan, let me ask you, would you win if you were following the state law of informed consent independently of the fact that it was a research protocol? In other words, so I think if you were to simply require that people trying to sue over research injuries establish the same proof that they would have to establish if they were suing on any other informed consent claim, many of the things that IRBs get wrong would not be so serious as to make a court say, this is not informed consent under Alabama law of recovery, because the informed consent standards frequently in state tort law are really, really high, because they got that way, because physicians saw that this was an end run around the expert witness requirements of malpractice, and so they really jacked up the state legal rules about what you had to do in order to effectively establish an informed consent case.
Well, the toughest thing that I've had to face is to try to convince the judges that informed consent in a medical malpractice case is different.
So you are saying that you can't live by the ordinary standard.
Well, I think the standard, I think I have a higher standard against the researcher in the research case. I don't think the informed consent document, and that's all it is in the medical case. I think it's a lower standard for the doctor than the research, than the informed consent in the context of human subject research. If the patient didn't read the informed consent document in the medical case,
Right.
that's too bad for him. If the patient didn't read the informed consent document in my research case, then I win. If the researcher doesn't believe that the subject understood the informed consent process, then I win.
Well, when you say you have a higher standard, I think what you mean is the physician has to prove more.
Absolutely.
I think they might think that you're claiming a lower standard was sufficient in these days. For example, the monkey deaths thing. How many of you think that if I were to take a drug and not be told that monkeys had died using a slightly different variation of this drug, would that be a basis for saying there was no informed consent to take the drug? No way in the world. Not a research drug, just an ordinary medical procedure. Some monkeys died. So what?
Well, it's certainly different. Well, it's certainly different when you're
I mean,
talking
in a
about
surgical procedure, for example, I mean, think, for example, of the original surgical procedures on heart. The very famous, my mind is blocking on that senior moment, Cooley versus DeBakey, or whatever it was down in Houston, where they first do these, all the monkeys died, right? Every single monkey died. And as I recall it, they didn't tell the first person how many monkeys had died. They said you could die from this, but they didn't say, oh, and by the way, the last 8 monkeys died. And it was held to be not a violation of the informed consent. So I'm just saying, in the context, we've got ribbons wrapped around the informed consent context in research. And really that's a very, very key position, because if all you have to do to get to the jury for nominal damages and punitive damages is to show that some subject didn't really understand what was going on, I mean, I'll bet that 50% of the research subjects in this city treated in the last 6 months at some level don't fully understand what's going on. And if you had to make them understand, the costs of research would be so extravagant you wouldn't be able to do it, because you can't communicate some of these concepts. You know, how do you communicate Bayesian theorem? Even to me, I can't even figure it out. You know?
Well, look, in the gene therapy context, when we were doing the Elsevier case, we talked to the gene therapy experts in the country. And one of the proposals that we had was you need to have a subject advocate, perhaps Jesse's doctor. And the head of the Gene Therapy Association said he wouldn't understand. Now, if the kid's doctor wouldn't understand, how is the handyman father and the 18-year-old kid going to understand? And if he can't understand, then you can't do it. It's just that simple. If you cannot convey the information in a way that the subject can make an informed decision, then you can't do it. I don't care how good this experiment is going to be, how wonderful the results are going to be.
And would you limit that to non-therapeutic experiment, or is it only is even within a therapeutic experiment if I can? Because if I can't understand it, that means when I get really sick,
Well, this Sunday,
you can't treat me.
this Sunday in the New York Times, I believe it's this Sunday, you'll see an article on the artificial heart patient in Philadelphia who died, who was a man of limited education, who was dying of heart disease, and was told, you're going to die in a week. And you can't get a regular heart transplant, but you can get an artificial heart. Now, they had a patient advocate in that case, and this patient advocate later told a medical school audience that the level of education of the subject made informed consent impossible. If there is no informed consent, you can't. If you can't get informed consent, you can't do the experiment. It's just that simple. It's not a medical procedure. It's not a situation where you say, you know, this kid needs this therapy. It's in the best interest of the kid to get this therapy. And so you bring in experts or doctors or somebody who's going to act. If you have parents who can't understand, and you bring in somebody who can understand and say, it's in the best interest of this kid to have this medical procedure. And so you get it done. But being a subject in a human experiment is a moral choice that only the subject can make.
Do we have questions and comments? We can just have a dialogue among all of us. So
Sure.
let's start that.
Oh, well, first of all, I'm very pleased. This is the first time in my over a year here that I have a chance to wear the other hat. I did make them make it Dr. Joy Hochstadt instead of only Joy Hochstadt class of 04 on this particular occasion. First, I want to say we are getting the technology that it may be too complicated for most people to understand. Today, we don't try to teach juries intermediate repetitive polymorphisms in order for them to accept DNA evidence. We get an expert witness who says that it's accepted science and what's not accepted science. What I have sat on IRBs, and since that I never heard the word since I was here. When I'm at a hospital and I sit on one, it's the internal review board. And when I'm on the NIH and I sat on one, it was the initial review board for a committee that was reviewing your request for money to do your research. We do not have clinicians that are well enough trained in science. And they're getting worse. The reason we had a group of clinicians that have made tremendous advances recently is from 1967, or not even before that, for at least 20 years, we had a universal male compulsory draft for MDs. Those MDs that were top of their class all wound up at the same time at the same place on the NIH campus in Bethesda, Maryland. They took their science with Marshall Nirenberg, with Earl Statman, whom I happen to train with all the best researchers who often were PhDs and not MDs, but they could fulfill their military requirements. That is not going on at this time. So even before, when we had clinicians who were better trained, now they will hire young people who are trained. Our IRBs don't know the first thing about how poor science. What we need to put on the IRBs, just as we invite for lunch speakers and give $200 or $250 to some young researcher who's going around making himself known for job possibilities in the future. Outside researchers have to be on the IRBs, capable of reviewing the basic science that underlies the clinical tests. In major institutions, they'll be able to, for major projects that are worth $7 million, they'll be able to give a little bigger honorarium and get some other guy in. The second, there is immediate conflict of interest, because the NIH grants, which eventually, sometimes when they come to the internal review board, is to get a little data, but eventually they're going to go outside and ask for more funding for this, all come with overhead, which means that if 35% of your personnel is working on NIH grants in a big university such as Columbia, including all the departments, 35% of your library, of your medical service, of your dean's salary, of everything gets paid. So everyone has an interest in getting as many grants because their very infrastructure depends on them. So there needs an outside board. The liability, not so much from the individual, because you're not going to get it, but if the tort budget came from the NIH research funds available to the rest of the research community, which meant that you had to get a higher priority score, that it was rated by your RIB better in order to get the grant in the first place, that would make a big difference. They would all wake up.
And do you have any suggestions or questions for the speakers? Do you have any comments regarding the tort liability, the work that Alan's doing as a way to get to that place?
Well, I think one of the things that I'd like to have a dialogue with him about is that when Hillary Clinton proposed her plan, I knew it would go nowhere, because we didn't want to go to where Europe goes. For those of us who are privileged, the power structure, we have better medical care. We have wonderful drugs. We have everything. We don't want to stop that, but we have to get to the point where we're willing to pay for it. We're willing to pay for all these things of having more IRBs and putting more people on it. But the fact is, I'll just take one example. When this drug that they call Prilosec, the first purple pill, they knew that mice or rats had gotten cancer. And so they were very gingerly for the first couple of years. People who took it were only recommended to take it for 6 weeks. Then they realized it was safer. Now they're selling it over. They're going to sell it over the counter soon. And in fact, because their patents run out, they've come out with Nexium, which is a terrible drug that they're trying to get it in instead. And I think that I'd like to,
if you want to direct a comment or question directly to the speakers, and if not, I want to give we don't have that much time for questions and comments.
How do we balance our desire for better, bigger, quicker, with the thing, with the desire for ethics other than to make sure that the IRBs are all accountable, that the money comes from research funds, that it may indeed be that informed consent, because the lawyers aren't trained as doctors, may take a less role, that the role of the committee is both more accountable and more expertise. Go ahead.
I mean, that's the question. I mean, that's how do you synthesize what have been historically two really quite different strands.
Mrs. Kelly?
I just had a question. Mostly in your last point, I was following you up to the point where you said for therapeutic treatment that there was this one case where this person, because of their level of education, could never have given informed consent as you would like to see it. Isn't that a problem if we start saying that there are people because of their level of education cannot give informed consent? I mean, for therapeutic treatment, might we not want to have a different rule?
Well, that's a therapeutic clinical trial, though. I mean, it's a human experiment involving the artificial heart. They're not at the point where it's a therapeutic alternative. They're just developing this device so that one day it can be used as a therapeutic alternative. Now, can you have someone who is not educated as a human subject in that experiment? I think it's difficult. I think it's difficult.
Let me say that if you say that, you're sentencing the seriously schizophrenic to a life of constant serious schizophrenia, because you'll never be able to do the initial trials to see whether it works.
No, I don't agree with that. It's the same with children. Maryland Supreme Court case came out and said parents can't give informed consent for children in research where there's anything more than
No, but that was
minimal risk.
But that was non-therapeutic work. I mean, if I understand your response here, it's that even with respect to a therapy, the fact that a person cannot effectively consent bars your use for it. So if you really mean that, the consequence is you could not do phase 2 studies on drugs to cure schizophrenia in the seriously schizophrenic.
Here's how you can do it. And I've had this discussion with researchers down at St. Jude's Hospital, where they're doing research on children with cancer. And they're questioning me, well, are you saying we can't do this research? And my answer is no, I'm not saying that. The standard should simply be, if it's in the child's best interest to be a subject in your experiment, if it's in the child's best therapeutic interest to be the subject in your experiment, then you can do it. If it's in that schizophrenic's best therapeutic interest to be in that study, then he can be a subject. If it's not, then he can't be.
Then why can't the guy with the low education be in the test for the heart when he would have died in a week and now he lived another 200 days?
Well, I mean, that's a good question. I mean, they had a subject advocate in that case. They should have. The subject advocate didn't do his job. Is it conceivable that a patient like that with the right subject advocate might get to the point that he understands that this isn't a therapeutic alternative at the stage of development that this artificial heart is in, but it's simply an act of altruism that we're asking you to commit to, that we're asking you to do this, not for your own benefit, but to be a martyr for mankind. If he can understand that, after being told you're going to die in a week, then he can be a participant. But I think it's difficult. I think it's difficult. And the other problem that underscores this is in these kinds of experiments. And again, it should be in the Times this Sunday. I mean, one of the questions you should ask yourself if you read the article is, will people like Mr. Quinn, once the artificial heart is perfected and sold as a therapeutic alternative, will people like Mr. Quinn be the kind of person who gets it? Or is he only the kind of person who is a subject in an early phase experiment? And that's a real problem when you're talking about the artificial heart.
Yes.
Mr. Nelson, you made the decide what is and is not important?
The IRB should decide that. I understand that, you know, the institutions that I sue really can't stand this issue, and people try to convince me that is just an absolute act of heresy to say that you should limit the amount of research going on in this country. There is too much trivial research going on in this country. That's just a plain fact. Why is there 10 times more human subject experiments going on today than there were 10 years ago? Because it's all important? Is every experiment going on critical to the advancement of medicine and science? Is that why it's going on? Won't you concede that a lot of experiments are going on just because the researcher gets paid to do it? Just because he's up for tenure this year and needs to get some research monies in? And if there's trivial human subject research, it wastes human subject research resources. If there are 4,000 trials going on at Penn when Jesse Gelsinger gets killed, so that the IRB can't do the things it's supposed to do, is someone going to tell me that each of those 4,000 trials is critical, is being done for the advancement of medicine and science, and if it's not conducted, that somehow we as a society are really going to be lessened because of that? I just don't believe that. There's too much money in this game right now. And the money is driving the research. Now, which is not to say there's not terrifically important research going on. There is. But there's a lot of research going on because of the money.
Well, I just wonder why the people put up the money if they think the research is trivial. In other words, I grant you that there's no shortage of people who will do research, and if I can get money doing it, I'll do it. But the people, and I'm sure much research turns out to be trivial. But I would think that the people putting up the money for the research at the time they do it ordinarily think that it might have some chance of being significant. I actually, it's a standard puzzle in the bioethics literature also, of is it permissible to put human subjects at risk in order to train people to do human subjects research? So it's trivial. There's no research benefit. The only benefit is teaching the new generation how to become researchers. Is it permissible to, these are not huge risks, but somebody's got to learn how to do these things. So your intuition, I think, is no, you should never do that, but I don't know how else you train youngsters without some of these things. In any event, I faced it on IRBs on which I have sat, where we've permitted things that were almost certainly no consequence, very low risk, but just for purposes of helping people learn how to be researchers.
Mr. Googling?
Alan, I was very troubled about your observations of how subjects totally misperceive the purpose of the study. But I also wonder, you talk about the uneducated and mentally incompetent who can't give informed consent. The studies on choice under risk and uncertainty strongly imply that none of us can. That when it comes to this situation, none of us make accurate estimations as to the risk we're facing, especially when we lay on the cognitive dissonance that's going to come into play if we're desperate or ill. And so it seems to me if you're going to require any kind of strong sense of rationality, rational choice, that experimentation is over.
I don't think it's over. I think that's the importance of subject advocates. And the subject advocate will, in my view, be a doctor. Let's say you have a cancer patient, will be a doctor, independent of the research, who understands, perhaps as an oncologist, or somebody sophisticated enough so that this patient/subject, we have trouble just with the words. I guarantee you that all the individuals who are subjects think of themselves as patients. But so that this patient/subject can speak with a doctor and determine whether or not being in the research is in his or her best therapeutic interest. Because I think that is more often than not, the critical question for that subject.
We have used all the time that we have and then some, so we can continue our discussions downstairs. We have a reception. You're all invited to come, and I hope to see you there. And we'll give them a drink, and then they can talk a little bit more with you.